Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today for what we call arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have in this court is a criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are commonly referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony offense. Now, when I use the term serious, what I'm talking about is the possible punishment that a person can get if they're convicted of the charge. And I'm also talking about the facts of the case. Felonies are divided into 5 categories. And we'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life without the possibility of parole in the state penitentiary or death by lethal injection. Now, as I mentioned earlier, the case that you have in this court is a misdemeanor, so you don't have to worry about those punishments. Now, misdemeanor cases are divided into 3 categories, and we'll start at the top and work our way on down to the bottom. You have a Class A misdemeanor, Class B misdemeanor, and a Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is a fine that does not exceed $500. That's by fine only. Now, the Class C misdemeanors are cases that are normally handled in the city court, which is the municipal court, or the JP court, which is the justice court. For example, speeding ticket is a Class C, not having a seatbelt on, not wearing your seatbelt is a Class C, having an expired sticker on the vehicle is a Class C. Those are common Class C misdemeanors. They come to this court when a person is convicted in municipal court or JP court, and then they appeal their case. In essence, they want a higher court to review the case to see if they've been wrongfully convicted or whether or not that court committed an error. And then the case comes back here, the person get a whole new trial. But the punishment range does not change. Even though it comes to County Court at Law Number 2 or to County Court at Law, it does not change. Now, the next highest misdemeanor is a Class B misdemeanor. The range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days in the county jail, or a fine that does not exceed $2,000, or you could be given both such fine and confinement. Then you have the highest misdemeanor, which is a Class A misdemeanor. The range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days in the county jail, which is 1 year, a fine or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may qualify for probation. There are 2 types of probation. One type of probation is called unadjudicated probation. The other type of probation is called adjudicated probation. And the difference between the two is as follows. With unadjudicated probation, you do not have a conviction on your record. And if you successfully complete the probation, the case will be dismissed and you may qualify for what is called a non-disclosure. What a non-disclosure is basically means that your record is sealed to the general public. So the general public cannot have access to your criminal record if you get a non-disclosure. Now, the term that I use, I say general public. Now, the government can have access to it, even though you have a non-disclosure. The other type of probation is called adjudicated probation or regular probation. With adjudicated probation or regular probation, it does result in a conviction on your record. However, there's something that is called judicial clemency. Judicial clemency means that the judge or the court can set aside the conviction. And if the court sets aside a conviction, you no longer have a conviction. And in order for that to happen, you have to first successfully complete the probation. There cannot be any more time left on the probation. And you have to be successfully discharged or let off of the probation. If those three things happen, then the court has the discretion to grant you judicial clemency. And if the court grants you judicial clemency, you would no longer have a conviction on your record. However, if you get a subsequent conviction, meaning that if you get a conviction, another conviction later on after this case, then the case that you receive judicial clemency on can be resurrected, revived, brought back up and used against you. And if you try to get a license with CPS, they could either deny giving you a license, or if you have a license, they could suspend or revoke your license. Now, as a defendant in a criminal case, you have rights. One of the rights that you have is a right to have a trial, the right to have an attorney. The paperwork that has been handed out on the clipboard, the first document, there's a document on that clipboard that is titled Judge's Explanation of Rights to Defendants Without Attorney. On that document, it talks about your right to have an attorney. And I'm going to go over this document with you. And it states, as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. You can represent yourself. That simply means that, one, you know you have a right to have an attorney. However, you are waiving your right to have an attorney. Waiving your right to have an attorney means that you're giving up your right to have an attorney, and you will be representing yourself. All right. Now, if you want an attorney and you have enough money to hire an attorney, the case will be reset. Reset means that you'll be given another court date to give you time to hire your attorney. If you want an attorney and you do not have enough money to hire an attorney, then you will be required to fill out a financial questionnaire so that the proper person can determine whether or not to hire an attorney to represent you. Now, the questionnaire should be the second document on that clipboard, and is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. I'm going to go over that document with you in a few minutes. Now, going back to the document that I was originally talking about, the Judge's Explanation of Rights to Defendants Without an Attorney. If you want an attorney, do not have enough money to have an attorney, to hire an attorney, the case will be reset. Well, I mean, you would have to fill out the financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you want to represent yourself, that is, you want to waive your right to have an attorney or give up your right to have an attorney, you cannot, if you do that, you said you're representing yourself, you'll have an opportunity to talk to one of the two assistant district attorneys in court, the prosecutors, about your case. Now, you may not speak to the prosecutor unless you first sign a waiver of your right to be represented by an attorney. That's the second document that is on the clipboard, judges, and it's titled Waiver of Counsel for Purposes of Entering a Guilty Plea. So once you read and sign that document and you're waiving your right to an attorney, you'll have an opportunity to talk to one of the two prosecutors in court to see if you can settle your case. Now, when I use the term settle, there's something that's called a plea bargain. And what a plea bargain is, it's agreement that you work out with the state to settle your case. And I'll talk to you about that in a few minutes. Now, for those of you who will be waiving your right to an attorney and representing yourself, you should be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, that is, if you choose to proceed without an attorney, you may change your mind at any time and request that the court appoint an attorney to represent you. Now, at the bottom of the document, judge's explanation of rights, it states in bold letters, defendant's choice, mark initials next to only one choice. If your choice is to hire your own attorney, you will place your initials on the first line to the left. If you have already hired an attorney to represent you in this case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in this case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is to waive your right to have an attorney, to give up your right to have an attorney, then you will place your initials on the fifth line to the left. Now, once you have finished initially one of the 5 lines, then you will sign your name on the line that is titled defendant at the bottom of the document, and you will date it today's date, April 30th of 2024. Now, for those of you who will be waiving your right to have an attorney and representing, and you will be designed to represent yourself, you will have to read and sign a document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding a Trial. And I'm going to go over this document with you. And it states as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily. Voluntarily means that nobody is forcing you to do it. You're doing it of your own free will. My waiver is voluntarily and intelligently. Intelligently means that you know what you're doing. So my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 30th day of April of 2024 by County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. If that is your choice, that is, you want to waive your right to an attorney and represent yourself, then you will sign your name on the line that is titled defendant, and you will date it today's date, and today's date is April 30th of 2024. Now, as a defendant in a criminal case, you also have other rights. One other right that you have is a right to have a jury trial. Where a young lady is sitting in that area over there, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors in your case. They will listen to all the evidence. They will listen to all the arguments, and then they will deliberate. And then after deliberating, they will decide to find you either not guilty or guilty of your charge. You also have a right to waive your right to have a jury trial. That means you have a right to give up your right to have a jury trial. If you waive or give up your right to have a jury trial, your case will come before the court in one of 3 ways. One way it can come before the court is by way of a bench trial. And what a bench trial means is it's a trial without a jury, and it's a trial by judge only. The judge will be the judge and the jury in the case. The judge will listen to all the evidence and all the arguments, and then the judge will decide after applying the facts to the law, the judge will decide whether or not to find you not guilty or guilty. You also have a right to waive or give up your right to have a bench trial. And when you do that, you're not having a jury trial and you're not having a bench trial. And so the other way that your case can come before the judge is by way of a plea bargain. And as I mentioned earlier, what a plea bargain is, it's an agreement that you've worked out with the state to settle your case. Now, the second way it can come before the judge is by way of an agreed plea bargain agreement. That simply means that you and the state have reached an agreement concerning your case. Let's say, for example, you've talked to the prosecutor, your attorney talked to the prosecutor, they made an offer, and you've accepted the offer, and then the case will come before the judge. Then we call that an agreed plea bargain. The judge can do one of 2 things. The judge can accept the plea bargain agreement or reject the plea bargain agreement. If the judge accepts the plea bargain agreement, then if you decide within 30 days that you would like to appeal your case, one of the appeal is you would like to have a higher court to look at your case to see whether or not you've been wrongfully convicted or this court committed an error by convicting you. And if you want to appeal your case, you have to get permission from the judge who accepted the plea bargain agreement. Now, if the judge gives you permission to appeal your case will then leave this court and go to the Ninth Court of Appeals, which is located on the 3rd floor in this courthouse. They will review your case. They can do one of 2 things. They can either grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty. Case over. Or they can send the case back down to this court and order this court to give you a whole new trial. In essence, you start back at square one. If they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. Okay? You can appeal it to the highest criminal court in the state of Texas. It is called the Texas Court of Criminal Appeals, and they are located in Austin, Texas. You will have to file what is called a pro se petition for discretionary review. And I'll explain to you what that means. Pro se means that you are representing yourself. You don't have a lawyer representing you. You'll be representing yourself. and you'll be petitioning the court, the Texas Court of Criminal Appeals, to review your case to see whether or not your appeal should have been granted, or whether or not this court committed error by convicting you, or whether or not you were wrongfully convicted. They can do one or two things. They can grant your pro se petition, or they can deny your pro se petition. If they grant your pro se petition, they can just simply find you not guilty. Case over. Or they can send the case back to the Ninth Court of Appeals, or they could send it back to this court and ask this court to give you a whole new trial in this case. Now, if they deny your pro se petition, then at that point, your conviction will stand. Now, the other way that your case can come before the court, I stated that it can come before the court either by way of an agreed plea bargain agreement. Well, it can come by way of a bench trial, which is a trial by judge only, an agreed plea bargain agreement. The other way it can come before the judge is by way of an unagreed plea bargain agreement. Unagreed plea bargain agreement means that you and your attorney have talked to the state, the district attorney's office, and you all have not been able to reach an agreement to settle your case. And if that's the case, then your case will come before the judge. You're asking the judge to settle the case. In essence, you're asking the judge to assess the punishment. Okay. Now, I use the word plea, and I never did define what plea means. Okay, I will do that now. You have one of three types of pleas that you can enter. You can enter a plea of not guilty, guilty, or no contest. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. Or if you enter a plea of no contest, you're telling the court that you're not fighting the charges. Okay. Now, if you enter into a plea bargain agreement with the state, it will come before the judge, as I mentioned earlier. It can come before the judge by way of an unagreed plea bargain agreement or a plea bargain agreement. And if it's an unagreed plea bargain agreement, that just simply means that you and the state have not been able to reach a plea bargain. And so therefore, you want the judge to set the punishment within the punishment range. All right. Now, as a defendant in a criminal case, you also have not only a right to have a trial by jury, or a right to have a bench trial, or a right to have a plea bargain, agreed plea bargain agreement, or unagreed plea bargain agreement. You also have a right to have witnesses to come to court to testify. And what witnesses do, they sit in that chair where that microphone is, and they can testify. And you testify, they can testify for you or against you. If you're representing yourself, or if you have an attorney, you or your attorney can ask them questions. If you're representing yourself, you can ask the questions, or if you have an attorney, your attorney will ask questions. We call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court. And that simply means that you have a right not to have witnesses to come to court. Now, if you waive or give up the right to have witnesses to come to court, that means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in your case. Now, you also have what we call a Fifth Amendment right against self-incrimination. Fifth Amendment of the United States Constitution gives you the right to not incriminate yourself, not to testify against yourself in your case. State of Texas, the government, the DA's office cannot force you to take the witness stand if you exercise or invoke your Fifth Amendment right against self-incrimination. Now, you can waive it, meaning that you can give up your Fifth Amendment right against self-incrimination. If you do so, then you will be taking a witness stand in your case. But the state cannot force you to take the witness stand. Okay. Now, you also have a right to have what we call discovery. And discovery means that you have a right to see the evidence have access to the evidence that the state has against you. You have a right to have access to your statement, witness statements, police reports, lab reports, or any other reports. You have a right to see uh, video recordings, listen to audio recordings. You have a right to have access to any instruments that they may have or be using in the case that they have against you. We call that discovery. In essence, you have a right to discover or see what's in the state's file, to see the evidence. Now, you can waive or give up that right as well. Now, and if you are waiving or giving up the right for discovery, that means that you will not be having access to the evidence that the state will be using against you in your case. Now, everyone that's here today for arraignment, you're here because you have been one, arrested, and you're out of jail on bond. You're out of jail on one of um, three types of bond. You're out on a cash bond, which means that you paid the full amount of the bond to get out of jail, or you're out on a surety bond, which means that you paid a bondsman a percentage of the bond to get out of jail, or you're out of jail on what is called a PR, or a personal recognizance bond, which means that you did not have to put up any money to get out of jail. You were released under your own personal recognizance. Now, every day that you spent in jail, it can be used as credit toward your punishment. Now, I use the term every day that you spend in jail. You don't have to be in jail a whole 24 hours. If you're in jail 1 minute and you bonded out, that's considered a day. You was in jail that day. And so, for example, if you're in jail, if you go into jail you get booked in jail at 11:59 p.m. and you get out of jail 2 minutes later at 12:01 a.m., that's 2 days. It's 2 different days. All right. Even though you've been in jail 2 minutes, it's considered 2 days because it's 2 different days. Now, every day that you spent in jail can be used as credit towards your punishment. So, for example, let's say you spent 5 days in jail and you bonded out of jail. You and the state have, or you and your attorney in the state have reached a plea bargain agreement to settle your case. And the agreement is for you to serve 5 days. What that means is you won't have to serve any more time in jail because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you've already served. Okay. Now, if they are offering 7 days in jail and you spend 5 days in jail, that means you will only have to spend 2 days in jail because you've already spent 5. You're going to take 5 from the 7, that leaves 2. Every day that you spent in jail also can be used as credit towards your fine and court costs. You're credited at $100 per day. That will go towards your fine and court costs. So if you spent 5 days in jail, that's $500. That can go towards your fine and court costs. So if the state is offering you fine and court costs of $500, that simply means you won't have to pay anything. Why? Because you spent 5 days in jail. Your 5 days in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired. That simply means it's already paid. Now, if they are offering fine and court costs of $700, that means you would have to pay $200 because we'll take $500 from the $700. That leaves $200. Now, you'll be required to pay the $200 on the day that you dispose of your case. If you cannot pay the $200, then we can put you on a payment plan, which means we could allow you to pay it off over a period of time, so much a month, until it's paid off, depending on what your financial situation is. Now, depending on what your financial situation is, you might not be able to pay it off even if we put you on a payment plan. No problem, because we can convert it to community service. You will receive $12.50 credit toward every 1 hour of community service that you perform in this case. So, for example, if you have $200 in 8 hours, you do one 8-hour day, that's $100. Work 2 8 hours days, that's $200. So if you work 2 days, you can pay it off. Okay, 2 8 hour days. All right. Now, everyone that's here, um, you're here. Sometimes somebody might be your first time. You might have been here. This may not be your first time. Maybe your second or third or fourth or whatever. But what you need to understand is this. Jefferson County, the district attorney's office, has a program for first-time offenders that's called pretrial diversion. To make a long story short, they'll dismiss your case and you can get it wiped off your record. And the way it works is like this. Okay, it has to be your first time getting into trouble. And then two, it cannot be for an offense involving unlawfully carrying a weapon or resisting arrest. And three, you have to have an attorney to assist you with the application to get into the program. If you get into the program, case is dismissed, complete the program, you can get an expunge from your record. Expunge means erased, deleted, or wiped off from your criminal record. So it's like, I'm looking at this paper I have right in here. This is my criminal record. When it gets expunged, it looks like this. It doesn't have nothing on the criminal record. Okay, so it's erased, deleted, or wiped off from your criminal record. And as I mentioned earlier, if in order to qualify, it has to be your first time to get into trouble. It cannot be for an offense involving unlawful carrying a weapon or resisting arrest. And you have to get an attorney to assist you with making the application. All right. Now, this court has a program that is called a pretrial. We also have another program that the district attorney's office has. It's part of the pretrial diversion program. It's called Veterans Court. Veterans Court is a program for veterans only. And to participate in that program, you just have to be a veteran. And what they will do is you get into the program. Once you complete the program, the case is dismissed. And you can get what is called a non-disclosure. And as I mentioned to you earlier, what a non-disclosure is where your record is sealed to the general public. The general public cannot see your criminal record because it's sealed to them. However, the government can have access to the record. So we have DA's office has pretrial diversion, and they have the Veterans Court. Now, this court has a program that is called the CSI program. CSI stands for Community Safety Initiative. It is a program that I started within the first 100 days of taking office. And that program is designed to address the issue of what we call recidivism. Recidivism means when a person commits crimes over and over. All right. And so the way we address the issue of recidivism is through our CSI program, the Community Safety Initiative. And what the Community Safety Initiative is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and go to church. And with that program, we have partnerships with agencies in the community. One of the agencies that we have a partnership with is the Spindletop Center. It's our regional mental health center. And we have some individuals from Spindletop. They're going to come to you in a few minutes and tell you more about that program. But basically, the program that I started entails that Spindletop will do a private interview. They could either interview you in privacy in the jury room, over your telephone, or at their facility, depending on what is convenient and comfortable for you. The other thing is they have the ability to do an assessment. They can assess your issue, your mental health issue, and they can develop a treatment plan, either outpatient or inpatient, to address whatever mental health needs that you have. Now, you do not have to be insane or incompetent to participate in the program. You could merely suffer from anxiety or depression. And they have the expertise to address your mental health needs. Now, Spindletop also has a drug and recovery program that is called ATAR. ATAR stands for Addiction, Treatment, and Recovery. And we also have a partnership with our local Drug and Alcohol Council that has a similar program that is called OZAR. OZAR stands for Outreach, Screening, Assessment, and Referral. And with those programs, they can do a private screening, they can develop an assessment, and they can refer you for either outpatient or inpatient treatment to address your drug and alcohol addiction needs. Now, it's not uncommon for individuals to have what is called a co-occurring disorder, meaning that they can have they can have a drug problem and a mental health issue at the same time. Sometimes they can run together. And so Spindletop has the expertise to deal with both. Okay. Now, the other thing is this. If you're unemployed or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in any one of those areas that you select or that you choose, then they will assist you at getting a job in the area that you're trained in. If you have not graduated from high school, well, they have a GED program, graduate equivalency diploma. You can get your graduate equivalency diploma as well. Now, all of these programs that I mentioned to you are free. It does not cost you anything but time. And in this court, I like to say, we don't just give our time. We don't just give time, we take our time. And that simply means we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say in this court, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And if we make a difference in their life, we make a difference in their home. And if we make a difference in their home, we will make a difference in the community, because what comes out of the home goes into the community. And so with these programs, we are making Jefferson County a safer place. And the other thing about the program is this. All of these programs that I just mentioned can be used as community service toward your punishment. So for example, let's say you cannot pay your fine and court costs. It's converted to community service, and you have some mental issues that need to be addressed. While you're receiving mental health treatment 1 hour, that $12.50 is going toward paying your fine and court costs. Okay, 1 hour is going toward community service, and the other thing is you're in the program. Or let's say you're working on your GED. 1 hour is going toward the community service, and $12.50 is going toward the fine and court costs. Or if you're in getting job training, the same thing. Or if you are in a drug or alcohol treatment, the same thing. 1 hour goes toward community service, and $12.50 goes toward the fine and court costs. So I like to say that you're not killing two birds with one stone. You're killing three birds with one stone, because you're in the program, you get community service, and you have you're paying your fine and court costs. So all of these programs are free. And if you're interested, just let us know, because we have paperwork, we have brochures that we can give to you and point you in the right direction so that you can get started. Now, I mentioned to you earlier that we have individuals from Spindletop that's going to come before you and tell you more about their program. At this time, we have Chris and Deputy Hinton. They're going to come to you and tell you more about the program.
Thank you.
You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state commission here in the sheriff's office. This is my coworker, Chris. Now, Chris is a qualified mental health professional. Reason we are both here this morning in this courtroom is the judge cares about every single person that comes before the bench. Judge has found, and what statistics prove, is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you in your particular situation.
So as the judge mentioned, up here, that can look like anxiety and depression, that's something that all of us deal with at some point in our lives, statistically. And being involved in this process does not make it easier. I know the judge mentioned inpatient, outpatient, resources, but that's what those are. It's resources. We can't send anybody anywhere, but we can provide you information on whatever you need. Now, there's a lot, wherever he says mental health concerns, right? A lot of the stress that goes towards anxiety and depression can come from not having access to specific resources that we hardly need to live. There's a lot of really great community resources that are well funded, not just here, but in Texas in general, that are not well advertised. And sometimes even just finding the main portal can be a bit like jumping through hoops. And that's what we've done. It's one of those things where anything that we talk about, anything that you need help with, we can provide actual support, just talking in general. But anything else we work towards is going to be towards getting you what you need. Because this is not something anybody has to do for yourself. It's not something anybody has to do.
Maybe this is your first time to be in court, maybe it's your 10th time to be in court, there's still hope. In fact, what we're offering you today has the ability to change your life. We're gonna need something from you, and we need you to share that need with us, and Chris will explain exactly how you can do that very privately.
So on the clipboards out there, there is this form. This is meant for everybody. It doesn't matter if you're here as a supporter, if you're here as a defendant. It doesn't matter if you need pictures or if you're trying to get information for yourself or someone you care about, right? What matters is that this is built like a baseline HIPAA consent form, so that you know that any information that you put on there is protected under state law, same as your medical information. The only thing this allows me to do is contact you once in a manner of your choosing, or talk to you privately back there, and just either provide that support or work with you to help find what you need. Now, again, it's not gonna be a robocall situation. I'm not gonna blow up y'all's phones. I respect y'all's time way too much to do that. But the big thing about it is getting you that contact. So that even if you don't have anything that you specifically know you need at this time, just having that number to reach out to and talk to, it'll be my work number or my work email, just like email. The only person that ever picks that up with those text messages is me. Making people have that event that you need someone to talk to, or that you need information, because there's a lot of stress that comes from just not being able to find the right information.
I also have a flyer here that I'm gonna get in everyone's hands before you leave for today. In the back, it tells you some of the advantages, back with just, you know, front it also has 1-800 numbers you can find yourself, and that's if you can call that number.
And that's not the important thing, is getting you those contacts, they're getting you those resources, while you will have my work number. That number is active statewide 24/7. It does not matter if it's 6 a.m. on Christmas Day. Typically, as long as there's a cell signal, it does not matter where you're calling from. If that number, they'll pick up. They can talk you through whatever's going on, or they can get you help immediately. And typically, they can work through whatever resources are in your area. We have a lot of people who come to court from Jefferson County that are from nowhere close to here, and it does not matter. We have people work with us that weren't even from the state. What matters is that you're involved. We're here to help in whatever way you need. It doesn't matter where you're from. It doesn't matter who the information's for. We're just here to help you get it. So as long as you can tell me, as long as you fill this out, and I will give out extras whenever we walk back out during the recess. We'll give them up to everybody who wants them. As long as you fill this out, you will hear from me. Even if you don't want to contact, what matters is that you have that contact. So if you guys have any questions, or if you have something you know you need, we're gonna be here about the entirety of the court. We're gonna be here to help in whatever.
Just shortly, the court's gonna go into recess. When it does, we'll come out there, we'll visit with you, and everyone will pick up those documents from you, and we'll answer any questions you have. Thank you, Your Honor.
All right, thank you, Deputy Hinton and Chris. Ladies and gentlemen, the paperwork that you have in your hands we're going to pick that paperwork up from you. We're gonna go over that paperwork, and then we're gonna call you up before the bench one at a time. Now, it's gonna take us some time to go through the paperwork, and if you need to use the restroom, there are two restrooms that are right outside in the hall. The men's restroom is in front of County Court at Law number 2, excuse me, in front of County Court at Law number 3. And the female restroom is in front of the 172nd District Court on the opposite side of the hall. Now, do not leave the courthouse. If you leave the courthouse and your name is called, if you're not here, then your bond can be forfeited. And if your bond is forfeited, a warrant will be issued for your arrest. If you need any help with the paperwork, we have our court personnel who's here, who will be happy to help you with the paperwork. And those of you who need help with the paperwork, I'm gonna ask that you raise your hands. And so, okay. And so folks on this side need help. Our court personnel will come out and help you with the paperwork. And at this time, the court is going to go into recess to give you enough time to finish the paperwork and for us to pick it up. Okay? At this time, the court will be in recess. Jose Torres Rivera. Okay. We have Jose A. Torres Rivera. Mr. Rivera speaks Spanish. We have a Spanish translator. Ms. Jennifer Araji. Ms. Araji, would you please raise your right hand? Ms. Araji, do you swear to interpret Spanish to English and English to Spanish, so help you God?
Yes.
Okay, you may put your hand down. How are you doing, Ms. Araji?
Good, Judge. Thank you for
Yes.
yourself.
I'm doing fine, thanks for asking. Ms. Araji, ask Mr. Torres Rivera if his full name is Jose Torres Rivera.
Yes.
Ask Mr. Rivera to please raise his right hand. Mr. Rivera, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, you may put your hand down. How are you doing, Mr. Rivera? Good. Mr. Rivera, I have before me a document that is titled Judicial Explanation of Rights to Defendants Without Attorney. Ask him, does he recognize this document?
Oh. Yes.
Is this your signature on the line that is titled Defendant? And are these your initials on a line that states you'd like to apply for court-appointed attorney?
Yes.
Ask him if, before he read this document, well, did someone explain this document to him in Spanish? You explained to him? Okay. And ask him if everything in this document is true and correct to the best of his knowledge.
Yes.
Okay. Mr. Torres Rivera. Okay. Also, I have another document here that's titled, it's an affidavit of indigence. Ask him if he recognizes this document.
Yes.
Now, this document is in Spanish. Ask him if he understood everything in this document. And is everything in this document true and correct to the best of his knowledge?
Yes.
Tell Mr. Rivera, I read his answers. Based on his answers, he meets the eligibility requirement for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent him is Attorney Charles Rojas, who speaks Spanish. Okay, tell Mr. Rivera that this will conclude his case. He can stand. I guess just you stand in front of the court coordinator, the case will be reset. And the court coordinator will give him information on how to contact his attorney, and his attorney will be given information on how to contact him.
Yes, sir.
There you go. Okay, tell him to have a blessed day. Okay. Next case is cause number 24CCCR0276. Case is style the state of Texas versus Jose Abraham Cardenas. Mr. Cardenas, your full name is Jose Abraham Cardenas?
Yes, sir.
Mr. Cardenas, would you please raise your right hand? Mr. Cardenas, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Cardenas, you may put your hand down. How are you doing, Mr. Cardenas? I'm doing fine, thanks for asking. Mr. Cardenas, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you would like to have your case reset to hire your own attorney?
Yes, sir.
I also have, now, Mr. Cardenas, before you signed and initialed this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge?
Yes.
Mr. Cardenas, I read the answers. Your case is going to be reset to give you an opportunity to hire an attorney, but before the court coordinator to do that, I need to give you some bond conditions. The bailiff is handing you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title? Okay, I'm going to go over this document with you, and it reads as follows. Following return of a criminal information to County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 applies. Condition number 3 states that defendants shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
And condition number 4 does not apply. That only applies in the DWI case. However, condition number 5 does apply, and condition number 5 states that defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Sure.
Now, Mr. Cardenas, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
Okay, now, Mr. Cardenas, you can stand in front of the court coordinator right over here. And once she gives you the information, you're free to go. And you have a blessed day. All right, thank you. Next case is cause number 24CCCR0730, case of style of state of Texas versus Henry Lee Reed. Mr. Reed, your full name is Henry Lee Reed.
Sir.
How are you doing, Mr. Reed?
Yes, sir.
I'm doing fine. Thanks for asking. Mr. Reed, would you please raise your right hand? Mr. Reed, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Reed, you may put your hand down. Mr. Reed, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you'd like to have your case reset so that you can hire your own attorney?
Yes, sir.
Mr. Reed, before you signed this document, signed and initialed the document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Mr. Reed, your case is going to be reset to give you time to hire an attorney, but before that is done by the court coordinator, I need to give you some bond conditions. The bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. You see that document?
Yes, sir.
Okay, Mr. Reed, I'm going to go over this document with you. And it reads as follows. Following return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to an additional condition, Number 1, the defendant shall commit no offenses against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Condition number 3 does not apply. However, condition number 4 does apply because the offense that you've been charged with, which is a DWI second, is a subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code. And condition number 4 states as follows. A defendant whose information charges any subsequent offense listed under section 4904 through 4906 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator. And said device shall be installed at the defendant's expense, with written verification of such installation being submitted to the court on or before 3 days after today. Do you understand that condition?
Yes, sir.
Condition number 5 states the defendant shall obtain, maintain, pay for, and have no violations with the ignition interlock device / mobile breath device. Any violations will be grounds for revocation. That means that your bond can be revoked. Do you understand that?
Yes, sir.
And condition number 6, the defendant must attend AANA meetings 3 times a week and provide proof to the court. And I'm going to give you a sign-up sheet and locations where you could attend the AANA meetings in Southeast Texas. Now, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. Do you understand that?
Sir, I have a question.
Yes.
On number 4, how do I get written verification to the court? I already have a breathalyzer installed,
Okay.
but how do I?
Well, you can, we can give you a fax or email it or fax it to us.
Just have a company write something?
No, didn't they give you a receipt? They should have gave you something.
Probably send me an email. Maybe.
They probably gave you some paperwork or something. You need some paperwork documenting the fact that you have the interlock. Okay, and you have 3 days to get that to us. The other thing is for the AANA meeting, Ms. Bailey. I'm gonna hand you, she's gonna hand you 2 documents. First document is a document that you need to bring with you to the AANA meetings. They will sign the document every time that you go, sign and date it. And you need to bring that document back to court every time that you come to court. Okay? And the other document is locations where you can attend AANA meetings. All right? Now, you have any other questions?
No, sir.
All right. Just please stand in front of the court coordinator. She'll reset your case. Once your case is reset, you're free to go and you have a blessed day. Thank you. Next case is cause number, let's see. Next two cases are cause number 24CCCR 0092 and cause number 24CCCR 0098. Both cases are styled the state of Texas versus Isaiah Christopher Martin. Mr. Martin, your full name is Isaiah Christopher Martin. Mr. Martin, would you please raise your right hand? Mr. Martin, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Mr. Martin, you may put your hand down. How are you doing, Mr. Martin?
How about yourself?
Oh, I'm doing fine. Thanks for asking. Now, Mr. Martin, I have before me two documents. The document is titled, the first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
Is this your signature on the line that's titled defendant?
Yes.
And are these your initials on the line stating that you like to waive your right to an attorney and you would like to represent yourself?
Yes.
I have another document here that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
Mr. Martin, before you signed and initialed these documents, did you read the documents?
Yes.
And did you understand everything that you read?
Yes.
And is everything in these documents true and correct
Yes.
to the best of your knowledge?
Yes.
Okay, Mr. Martin, I read your answers. We'll have someone from the district attorney's office to talk to you about your case. You can just go back and have a seat where you're sitting. Yeah. Mr. Rowe, do you recognize this document?
Yes, sir.
And is this your signature on the line that cited defendant?
Yes, sir.
Or are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have a document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there is a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Mr. Rowe, before you sign and initial all of these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything on these documents true and correct?
Yes, sir.
To the best of your knowledge? Mr. Rowe, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Mark Faggart. Attorney Faggart will be given information to contact you, and you will be given information to contact him. Our court reporter will give you that information, but before she gives you that information, she needs to give you, the bailiff is going to give you some bond conditions. Mr. Rowe, the bailiff is handing you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes, sir.
I'm going to go over this document, which and it reads as follows. Following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol in the test in the case of presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Now, condition number 3 does not apply, and condition number 4 does not apply. However, condition 5 and 6 does apply. Condition number 5, 6, and 7 does apply. Condition number 5 states that you will obtain and participate in the Spindletop ATAR, which is the Addiction Treatment and Recovery Program. Do you understand that condition?
Yes, sir.
And condition number 6, you will remain drug and alcohol free. You understand that condition?
Yes, sir.
And condition number 7, you'll participate in the ASAP program with Spindletop Center at 2750 South 4th Street, South 8th Street in Beaumont, Texas, Building C 77701. Do you understand that condition?
Yes, sir.
Now, Mr. Rowe, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, the warrant will issue for your arrest, you'll be arrested and placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
Okay, Mr. Rowe, our court coordinator is going to reset your case. Please stand in front of the court coordinator. Just have a seat in that first chair by the wall. Once she resets your case, you're free to go and you have a blessed day.
Are you all?
Thank you.
Your Honor.
I love it. Next case is cause number 24CCCR 0280, case is style of state of Texas versus Jamarian Robinson. Miss Bailiff, Miss Bailey.
Yes, sir. Can we get it back to him?
No, not the end. Okay. Stand in front of the bench. Your full name is Jamarian B. Robinson. Mr. Robinson, would you please raise your right hand? Mr. Robinson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Mr. Robinson, you may put your hand down. How are you doing, Mr. Robinson? You doing good? That's good. Now, Mr. Robinson, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document? And is this your signature on the line that's titled defendant? And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I have another document before me. This document is titled Affidavit of Jefferson County Affidavit of Injuries. You recognize this document?
Yes.
On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Mr. Robinson, before you sign and initial all of these documents that I just showed you, did you read the document? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Robinson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney David Grove. Attorney Grove will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat on that third chair on the wall. The affidavit of injuries?
No.
He already has,
So you want to-
he just needed an affidavit of injuries. Next case is cause number 24CCCR 0266. Case is style of state of Texas versus Larry Frank. Mr. Frank, your full name is Larry Jermichael Frank.
Yes, sir.
Mr. Frank, would you please raise your right hand? Mr. Frank, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Frank, you may put your hand down. How are you doing, Mr. Frank? You doing fine? That's good, Mr. Frank. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Mr. Frank, do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you would like to have your case reset to hire your own attorney?
Yes, sir.
Now, before you sign and initial this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge? Okay, Mr. Frank, your case is going to be reset to give you an opportunity or time to hire an attorney. But before you're released, bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. I'm going to go over this bond conditions with you. And it states as follows: following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds are executed for release of any defendant named herein or orders subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, sir.
Okay, condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or submit to a test for drugs and alcohol and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition? And condition number 3 does not apply. Condition number 4 does not apply. However, condition number 5, 6, and 7 does apply. Condition number 5 states that you will obtain and participate in the Spindletop ATAR, which stands for Addiction Treatment and Recovery Program. Do you understand that condition? And condition number 6, you will remain drug and alcohol free. Do you understand that condition? And condition number 7, you participate in ASAP program with the Spindletop Center, 2750 South 8th Street, Beaumont, Texas, building C 77701. Do you understand that? Okay. Now, all of these last 3 programs is with Spindletop, and that's the address that is on the document. So you have to go there, and they'll tell you what you need to do. Okay. Now, before you release, the court coordinator is going to give you your reset, give you an opportunity to hire your attorney. Once she gives you that reset, you're free to go and you have a blessed day. Please have a seat in that first chair on the wall. Next case is cause number 24CCCR0218, case of style of the state of Texas versus Dominic Stewart. Mr. Stewart, your full name is Dominic Stewart?
Yes, sir.
Mr. Stewart, would you please raise your right hand? Mr. Stewart, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Mr. Stewart, you may put your hand down. How are you doing, Mr. Stewart?
Right.
I'm doing fine, thanks for asking, Mr. Stewart. I have before me a document that is titled Judge's Explanation of Rights to Defendants without Attorney. You recognize this document?
Yes,
And is this your signature on the line that's titled defendant?
yes,
Or are these your initials that state you like to apply for court-appointed attorney?
yes.
I also have a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yeah.
And on page 2 of the same document, there's a signature above the line that's titled defendant signature. Is this your signature?
Yes.
Mr. Stewart, before you sign and initiate these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Now, Mr. Stewart, I have a couple of questions I need to ask you regarding some information on this document. Now, the information that I'm going to ask may be considered confidential, and so it is non-public. And so pursuant to Article 1.24 of the Texas Code of Criminal Procedure, all trials and proceedings in the court shall be public. However, pursuant to the case of Lilly versus State 365, Southwest 3rd 321, the right to a public trial is not absolute and may be outweighed by other competing interests, such as the interest in security, to prevent the disclosure of non-public information, or to ensure that you get a fair trial. So basically, you have a right to have this hearing closed to the public to prevent the disclosure of non-public information. Right now, we are airing on YouTube, and we have people in the courtroom. And so if you request that this hearing be closed to the public, I'm going to turn off the YouTube. I'm going to ask the folks in the courtroom to step outside so that they cannot hear your private information. Do you understand that?
Yeah.
So at this time, do you request that the court close this hearing to the public? Okay. The court finds that
That door is locked, though.
the request to close the public to the hearing is justified based on the fact that it would disclose non-public information. The court also finds that the closure is no broader than necessary to protect your interests. And the court has considered also alternative means, and the court finds that the closing is necessary. And so at this time, based on the findings, the court will close this hearing to the public.